In his ruling on Monday, delivered via email, High Court Judge Bernard Namanya nullified Elias Nalukoola Luimbazi's election as a directly elected Member of Parliament, Kawempe North, declaring the seat vacant. He also tasked the Electoral Commission to conduct a fresh election. In his ruling, he chastised the Electoral Commission for disenfranchising 16,640 voters in the constituency by ignoring the votes cast in 14 polling stations out of the 180 polling stations in the constituency. However, City lawyer Stephen Kalali disagrees with the High Court's decision, arguing that there was no justification for nullification of Nalukoola's victory under the circumstances.
You look at the substantiality test and then the bigger picture as a whole. I don't think that minor, I would call it minor failure to declare results or reconduct elections at those 14 polling stations would be sufficient or adequate to nullify those elections, because there was no justification that if those people voted, they would have given Inambi.
We legally, we factually and logically disagree with the judgment of court, because it has defied all the known legal principles. And on that alone, we have instructions from both Honorable Nalukoola and the party to challenge this finding of court.
Constitutional lawyer Peter Walibiri says Nalukoola had 7 days within which to present the notice of appeal in writing or verbally.
He had another 6 days to file. So after filing the notice of appeal, then you file another document.
According to the procedures, the notice is to be accompanied by a memorandum of appeal, a summary of the grounds for appeal in 7 days, and a third document called the record of appeal to be submitted 30 days after filing the memorandum.
By my calculation, then Mr. Nalukoola will have up to 3rd of July to file. But that presupposes that he files the memorandum on the last day.
The Court of Appeal has a further 30 days to hear the appeal and 6 months for the court to deliver its ruling. And when the judgment is out and the appeal dismissed, the Commission has 60 days within which to conduct the said election.
So this would mean the court, if Court of Appeal is to sit and determine this election petition appeal, it would probably at least be determined by let's say 15th day of July.
According to Article 81(3) of the Constitution and Section 3(2) of the Parliamentary Elections Act, the Electoral Commission is barred from running any by-election 6 months before a general election. So, we asked the land friends about the chances of another poll before the 14th June deadline.
Now, if the elections really are on 14th January for 2026 for Parliament, then it's not possible to hold elections, because that means that you hold these by-elections by 13th July, and it's not possible to comply with the schedule for holding this appeal by 13th July.
So that's why I'm saying that we really have, I think, a legal dilemma here now. Because constitutionally, the Electoral Commission, in my understanding, once Honorable Nalukoola puts in his proper appeal, as I've seen the notice of appeal, it would mean we cannot have a by-election for Kawempe North constituency, pursuant to Article 81.
What about other options for the appeals court, such as the possibility of the court ordering that Nambi is sworn in, if Nalukoola's appeal is dismissed?
These are not some of the prayers she asked for while filing the petition. She didn't ask for that. She thought nullification and setting aside the elections, which is what Justice Bernard did.
Under the prevailing circumstances and the limited time left, what then could be the fate of the Kawempe North residents?
If the appeal is lost and then the time 6 month period kicks in, then Kawempe will have no member of parliament. Yeah, until the next general election.
Kawempe North constituency would be looked at as an area or constituency that finished the term of 2025 without a member of parliament.
For now, we can only watch the space. I'm Benjamin Jumbe, NTV.